this session, we explore the essential steps for vetting contractor agreements to ensure they align perfectly with your organization's requirements for confidentiality, intellectual property, and liability management. When a business engages external talent to build software, design systems, or provide specialized consulting, the legal document serves as the primary boundary for that relationship. Typically, a well-vetted agreement prevents the ambiguity that leads to expensive disputes over who owns the final product and who is responsible when things go wrong. What this means is that a cybersecurity or governance professional must look beyond the hourly rate and the project timeline to the underlying legal protections. By mastering these specific vetting techniques, you ensure that every external engagement strengthens your organization's posture rather than creating a hidden vulnerability in your corporate legal structure. Before we continue, a quick note. This audio course is a companion to our course companion books. The first book is about the exam and provides detailed information on how to pass it best. The second book is a Kindle-only ebook that contains 1,000 flashcards that can be used on your mobile device or Kindle. Check them both out at cyber.author.me in the Bare Metal Study Guide series. Contractor agreements are formal legal instruments that define the specific scope of work to be performed and, perhaps most importantly, establish who owns the resulting products, designs, or source code. Unlike a standard employment relationship where the company typically owns everything created on the clock, a contractor relationship is often governed by different legal default rules depending on your jurisdiction. In practice, without a clear written contract, the ownership of a digital asset might remain with the individual creator rather than the company that paid for it. Typically, these agreements must be explicit about the transfer of rights and the expected deliverables to avoid any future confusion regarding the origins of your technical assets. Understanding this foundational distinction is the first step in managing a successful and legally secure external workforce. A highly effective way to protect your organization is to practice by ensuring that every single agreement includes a strong and enforceable non-disclosure clause to protect your sensitive business secrets. When a contractor enters your environment, they often gain access to proprietary data, internal workflows, and strategic plans that are not available to the general public. In practice, the non-disclosure agreement, NDA, creates a legal obligation for the contractor to maintain the secrecy of this information both during and after the project is complete. Typically, a professional review verifies that the definition of confidential information is broad enough to cover all the sensitive assets the contractor might touch. This specific protection is what allows your organization to collaborate with external experts without fearing the loss of its competitive advantage. A major and potentially devastating pitfall frequently observed in the technology sector is the assumption that your company automatically owns any work created by a contractor simply because a payment was made. In many legal systems, the default rule is that the individual creator holds the copyright to their work unless there is a written assignment of those rights to the hiring entity. In practice, this means that if you forget to include a specific intellectual property transfer clause, you may only have a limited license to use the software you paid to have developed. Typically, this realization only occurs years later during an acquisition or a funding round, where investors find a cloud on the title of your core technology. By addressing this at the start of the engagement, you protect the long-term value and ownership of your organization's innovations. You can achieve a significant quick win for your risk management program by verifying that all external contractors maintain adequate insurance coverage for the work they are performing. This typically includes professional liability insurance, often called errors and omissions, E&O, insurance, as well as general liability and cyber insurance if they are handling sensitive data. In practice, if a contractor's mistake leads to a massive system outage or a data breach, their insurance policy provides the financial backing necessary to cover the resulting damages and legal claims. Typically, your contract should specify the minimum coverage amounts and require the contractor to provide a certificate of insurance as proof before they begin work. This verification step ensures that your organization is not left holding the bill for an external partner's professional negligence. It is worth taking a moment to visualize the professional clarity and peace of mind that comes from a well-defined scope of work that leaves no room for disagreement. A vague description of tasks is the most common cause of scope creep. and legal disputes regarding whether a contractor has fulfilled their contractual obligations to the business. In practice, the scope should be a detailed attachment that lists specific milestones, technical requirements, and acceptance criteria for every phase of the project. Typically, when the expectations are clear and measurable, both the contractor and the project manager can work toward a successful outcome with total alignment. This level of detail in the planning phase is what distinguishes a professional and disciplined procurement process from a casual and risky one. In the field of intellectual property law, we use the specific legal term work made for hire to clarify that your company is the legal author and owner of the intellectual property created. Under the United States, U.S. Copyright Act, this phrase has a very specific meaning and ensures that the rights to the work belong to the employer or the hiring party from the moment of creation. In practice, your contractor agreements should explicitly state that all deliverables are considered a work made for hire and include a backup clause that assigns any remaining rights to the organization. Typically, this belt and suspenders approach provides the highest level of legal certainty regarding the ownership of your software, media, and technical designs. What this means is that you are using standardized legal language to cement your organization's control over its digital future. Reviewing the indemnification section of a contractor agreement is a critical task that ensures the contractor will pay for all legal costs and damages if their work infringes on a third party's patent or copyright. For example, if a developer accidentally includes stolen code in your application and you are sued by the original owner, the contractor should be the one responsible for the defense. In practice, an indemnification clause acts as a powerful shift in risk, placing the burden of legal compliance on the person who is actually creating the work. Typically, a professional review ensures that this protection is not capped at an unreasonably low amount and that it covers the full scope of the contractor's activities. This clause is an essential safeguard that protects the organization's treasury from the high costs of intellectual property litigation. Imagine a challenging and stressful scenario where a former contractor claims they still own the core software they wrote for your company and threatens to sue you for its continued use. Without a strong, vetted agreement that includes clear assignment language, this individual might have a valid legal claim that could stop your business operations or prevent a future sale of the company. In practice, these ownership disputes are often expensive, time-consuming, and deeply damaging to the organization's reputation among investors and customers. Typically, the presence of a well-drafted contract is enough to deter such claims before they ever reach a courtroom or a public forum. This realization highlights why the vetting of contractor agreements is a foundational part of protecting the organization's most valuable and tangible assets and its overall enterprise value. It is vital to always remember that the contract is the primary and often only tool for managing the unique legal and technical risks associated with using outside labor. Contractors are not employees, and therefore they do not fall under the same internal HR policies or the same statutory protections that govern your standard workforce. In practice, this means that every protection you want, from background checks to specific security standards, must be explicitly written into the agreement to be enforceable. Typically, a seasoned governance practitioner treats a contractor engagement as a specialized mini-project that requires its own set of customized legal and technical guardrails. This disciplined approach ensures that your organization remains protected even as it scales its operations through the use of flexible, external talent. In this lesson, we have discussed the critical clauses that protect your assets when working with external professional contractors, including non-disclosure, intellectual property transfer, and indemnification. By integrating these requirements into your standard onboarding process, you are building a more secure and legally defensible environment for collaboration and innovation. Typically, the most successful organizations are those that view their contractors as partners while maintaining a healthy and professional respect for the legal boundaries of the relationship. In practice, a strong agreement does not just protect you from failure. It provides the clear structure necessary for the contractor to deliver their best work with total confidence. This integrated approach to vetting is a key differentiator for the modern security and compliance professional. A highly effective technique for maintaining consistency is to use a standard template for contractor engagement to ensure that every single agreement meets your organization's minimum legal and security standards. This template, vetted by legal counsel, should include all the essential clauses we have discussed today and serve as the starting point for every new negotiation. In practice, having a pre-approved standard form reduces the administrative burden on your team and ensures that no critical protections are accidentally omitted during a busy workday. Typically, if a contractor asks to use their own form, you should use your template as a comparison tool to identify what is missing or what needs to be added. This structured approach ensures that your organization maintains a high level of professional rigor across its entire external supply chain. Vetting these agreements thoroughly prevents future legal battles over ownership and responsibility for project failures, which can be devastating for a growing business. By addressing the what-if scenarios early in the relationship, you are essentially buying a form of legal insurance that protects the organization's time, money, and reputation. In practice, the energy you spend on a contract review today is a direct investment in the long-term stability and security of the company's digital and creative assets. Typically, the most mature organizations are those that recognize that their legal and technical domains are inextricably linked and must be managed together with a high degree of precision. This focus on vetting is what ensures that your organization remains a respected and legally sound participant in the global digital economy. This concludes our unit on how to vet contractor agreements for confidentiality, intellectual property, and liability alignment to protect your organization's interests. We have discussed the importance of work-made-for-hire language, the role of indemnification, and the necessity of using standard templates and insurance verification for all external engagements. A warm and very practical next step for your own professional growth is to take a moment today and check if your organization's standard contractor agreement includes a strong confidentiality and non-disclosure clause. If you have access to a past agreement, read through it to see if the intellectual property assignment language is clear and unambiguous regarding who owns the final product. Moving forward with this critical eye will help you become an expert at managing the unique risks and opportunities of the modern external workforce.
Thanks for listening. For more audio courses, daily newsletters, and more, please visit DailyCyber.News.